Hi, guys, and welcome to another informative episode of the Legal Digest. Today, I'll be talking about succession law in Kenya. So, I'll do a very brief introduction of what is succession law, the classification of succession law, who are entitled to apply for letters of administration under the current succession laws in Kenya, and the various grants that have been provided for in the laws and the system of Kenya. So with that brief introduction, sit back and enjoy today's presentation. So the law of succession in Kenya is governed by a statute that is called the Law of Succession Act. So the Law of Succession Act has provided for two classification of grants, or two ways one can approach the court when they are petitioning for a grant or letters of administration. So one is called the letters of administration. So for letters of administration, those are applied for if a person dies without leaving a will behind. And two, is normally called a grant of probate. So a petition for letters of administration for grant of probate are typically applied for if one has left a valid will behind as to how he or she intends his or her estate to be distributed after his or her demise. So we have to appreciate that the Law of Succession Act has provided for, specifically in letters of administration, for the people who are entitled to petition for letters of administration in case a person dies without leaving a valid will. And for one, the law has provided and stated that the spouse or wife or husband, they're the ones who have priority, and then they are followed by children. If children were not left behind by the deceased, then the deceased's mother or father can apply, or if the father or mother are not available, then the deceased's brother, and so on and so forth. So you first and foremost have to establish your locus before you petition for letters of administration intestate. For grant of probate, it doesn't matter your capacity, so long as you've been appointed as an executor of the will and you're listed as a beneficiary, then that is neither here nor there. The court will just act on the strength of the will, provided that the said will was prepared for and fulfilled all the provisions of the law in terms of validity of the same. And I think I will just dedicate a special session where I will be discussing about the validity of wills. I'll be giving brief distinctions between a will and a trust in as far as succession law is concerned. So what documents do you need before you approach the court for petitioning for letters of administration? One of the most important documents that you need to get is an original chief's letter. It has to be handwritten, and the chief's letter has to originate from either where the deceased died or where he originated from, so that whoever the official who writes that letter has to be certain and affirm to court that in fact he knows the deceased. He knew the deceased, he or she knew the deceased. He came from a particular location, and after his demise, he was survived with the following people. So that the chief is going to write the list of, we can just say, beneficiaries who are left behind by the deceased. So you have to get a copy of an original copy of the chief's letter. You need to have a death certificate. You have to obtain a death certificate, apply for one, and then finally you have to draft and fill the requisite petition for letters of administration forms, which obviously comes with a supporting affidavit. And then you have to get two sureties who are neither going to be appointed as administrators nor beneficiaries of the estate, who are going to act as sureties on behalf of the administrators, so that the work of the sureties will be to affirm to the court that they will indemnify the court to the extent of the losses that may be suffered by the estate if the administrators act negligently. So the choice of a surety has to be very well calculated, and I think during my practice I always advise my clients to ensure that they get someone who they trust. You shouldn't sign a surety document just because you know someone. So once you petition for letters of administration, you will pay over and above the requisite filing fees. You will have to pay for gazettement. So gazettement basically will enable the judiciary to publish the particulars of the petition in the Kenya Gazette. And what the law says about petitioning and gazettement is that anyone who feels that they need to be included in the as a beneficiary to the estate, or maybe a creditor, has been given, they are typically given a period of 30 days or 60 days to come and file an objection in court and tell the court the reason why they have to be included as a beneficiary, or they come and tell the court why they should be included as a creditor. So after the lapse of the 30 days, and if no objection is filed, then the court will go ahead and issue the grant as was petitioned according to the petition. And technically in law, those who are going to be appointed will officially assume the name of an administrator or administrators. So once you get the grant, you have to understand that that is not the end of the road. You have to go a further step and ensure that the grant has been confirmed. Recently, I think dating back from, there was a circular that was issued by the judiciary in 2018-2019, where they said that if you obtain a grant and you fail to have it confirmed within the next 6 months, then that grant will automatically stand as revoked. So you have to ensure that once you get a grant as administrators stroke beneficiaries of an estate, you have to push for the confirmation of the same and the eventual distribution of the estate. That is the only way that the court will know that it has concluded its part when it comes to a particular estate. So that you have to take note. If you fail to do that, the grant will stand revoked, and the estate will revert back to how it was when the deceased died. So you have to get the certificate of confirmation, and that will then give the administrators the powers to then now distribute the estate based on the mode of distribution that all the beneficiaries would have signed. So once you finish that, in law, we can say the succession process will be marked as settled, and the file will eventually be closed. So there are another question that that has really come across during my practice is people will come to our chambers, and I hope you've learned something new today. And if you have any questions or comments, you can please just leave them down in the comments below, and I'll be sure to answer every and all questions that may be asked. So thank you very much for watching this video till the end. Until next time, have a good one. Bye bye.